So, hi everybody, welcome back to Law Hero. My name is Jen, and if you haven't already done so, please subscribe for more videos because they're coming all the time. And now that things have slowed down a bit in August because the courts are closed and whatnot, I've been having more time to dig more into the law. And so today we're talking about equity, and obviously I've made a whole host of videos around equitable topics. I've done one around the maxims of equity. I haven't done one specifically on injunctions, but I don't think I need to because there's just so much knowledge out there. Neither have I done one on specific performance, but again, it's an equitable remedy, just like injunctions, that I don't think needs a lot of explaining. Today I want to speak about, and sorry, that goes as well for estoppel, like performance, injunctions, estoppel. I'm not going to really look at those. The other body of law then is trust law, and I have done some videos on trust, but today we're actually going to look at the equitable remedies of rectification and rescission, because they're very important in contract law, and I feel like they don't get enough time and people don't really learn about them, but that's what we're going to do today. So today is all about rectification and rescission. So we're going to start with rectification. And just like injunctions and just like specific performance, and indeed any equitable remedy, it is a discretionary remedy of the court, and indeed equitable jurisdiction is discretionary. We're going to look at, so to rectify something obviously means to fix it, and usually we're looking at a contract, so we're rectifying a contract. So for example, a contract doesn't contain what the true intention of the parties were. It needs to be rectified, and this can happen sometimes where incorrect details, for example installments around mortgages or who the mortgagees actually are. That's where I've seen it in practice, where you call on the court to rectify the deed. That's where I've seen it used in practice. It's an exception to the parole evidence rule, which means that oral evidence is inadmissible to alter a written instrument, that what is written is what is taken to be the gospel, and parole evidence, which is oral evidence, is usually inadmissible in court. So the courts will not rectify the instrument itself, but rather the mistake in the instrument recording the contract. And this was seen in Mackenzie-Colson. So rectification requires that a mistake is common to both parties, with the result that the written document does not contain the true agreement concluded between them. So for example, this means that both parties are mistaken as to what was recorded. So if both parties had agreed that, we'll say the repayments were €100 a month, and in the document it says €1,000 a month, that would be completely against the intention of the parties at the time the contract was drawn up. Written agreements will only be rectified if there's common mistake, and unilateral mistake, which is the mistake on the side of one party, will not lead to rectification. However, there is an exception that allows for rectification to take place in circumstances where the unilateral mistake is one of fact and not of law. And that goes to the maxim ignoratio juris non excusat, which means that ignorance of the law is no excuse. As we said, mutual mistake is the trigger usually for rectification, and that makes sense. It's because it's fair. Otherwise, parties could claim willy-nilly that some aspect of a contract is mistaken and try and renege on their promise. So to have an instrument rectified, it was necessary to prove that there was a valid contract in the first place. But the more modern view is that it's not necessary to show that a valid contract exists, and that was seen in Monaghan County Council v Vaughan. There also needs to be a continuing intention at the time the contract was signed, that there was an agreement reached between the parties before it was embodied in a formal document, and usually you would just get that from cross-examination. In Rooney v McPartland, it was held that in order to reach a settlement, it must be shown the parties had a common intention, which was not accurately recorded in the written agreement. So again, we'll use the example of wanting to pay €100 in installments for a mortgage, but instead €1,000 was recorded in the deed. So the following must be present. There must be a concluded agreement antecedent to the instrument which is sought to be rectified. So this could be like an oral agreement or heads of terms or commercial terms. Sometimes you'll have like an email or something like that. Hopefully somewhere else where it was recorded, written, but it doesn't have to be in writing. The antecedent agreement need not be binding in law, nor need not be in writing, as I just said, but they do help discharge the heavy burden of proof, which is what you are claiming is mistaken. And thirdly, a complete antecedent concluded contract is not required so long as there is a prior accord on the term of a proposed agreement outwardly expressed and communicated between the parties. And that just means that it could be, for example, heads of terms, which is an agreement to agree. It's not a legally binding document, so your antecedent proof doesn't need to be a formal written agreement. Okay. Now, let's look at the case of unilateral mistake. Now, the general rule of thumb is that there is no rectification for a unilateral mistake. However, the exception is if you can prove that the mistake was due to fraud. And the limits of this exception were seen in Irish Life Assurance v Dublin Land Securities, where it was said that provided there has been some element of fraud or sharp practice on the part of one person against whom the relief is sought, or to put it at its lowest, where it would be inequitable in the circumstances to allow for that person to retain a benefit derived from the mistake. And this is like this usual catch-all phrase with... Saki, stop. No. Saki? Saki? Shh. Shh. As I was saying before Saki interrupted me, that this is like the general catch-all, as in, if it would be inequitable for that to continue, well then we're not going to let it continue. But who knows what they mean by inequitable? I suppose it's around the maxims of equity. Okay, and now the last thing we're going to look at under rectification is proof of mistake. So historically, the proof required for actions in rectification was akin to the standard of proof in a criminal prosecution, which is beyond reasonable doubt, and that was in Fowler v Fowler, but that is no longer the case. We now look at the civil standard, which is the balance of probability, and that was seen in Thomas Bates and Sons v Wyndham Laundry. Again, in that Irish Life case, which went to the Supreme Court, it was held that there needs to be convincing evidence, which means that this needs to be reflected in some outward expression of accord, that the contract in writing did not represent the common continuing intention of the parties. So you basically need something to truly contradict what was put in the main agreement. And I think that's what they mean by convincing evidence. Okay. Now, let's move on to rescission as a remedy. It's a process by which a subsisting contract, so a contract which is existing, can be avoided at the behest of one of the parties. So what you want to do is put it to one side. You want to rescind it. It has the effect of nullifying the contract ab initio, which involves the termination of obligation under the contract and the restoration of the parties to their pre-contractual positions. So ab initio means from the point the contract came into being. Therefore, all of your obligations under the contract are null and void from the point of it beginning, whenever the start date or the commencement date was. Okay, so the primary difference between contractual rescission and equitable rescission is that in a contract, the parties decide it, as in they elect for it to be rescinded. However, with equitable rescission, the court is the one making the decision. Okay, so when would you use equitable rescission? There are 4 grounds. So there's mistake, misrepresentation, undue influence, and unconscionable transactions. So we aren't going to go through all of those. We know what mistake is. You can have a mutual mistake, which is also known as common mistake, or you can have a unilateral mistake. You can also have a mistake as to the subject matter or the parties to the contract. Misrepresentation does what it says in the tin. Undue influence, I've done plenty of videos on that. Unconscionable transactions I will speak about because I don't really think I've spoken about it before on my channel. So equity intervenes to set aside transactions that are made with ignorant persons in circumstances where an unfair advantage is taken. And I'm just thinking, for example, last night I was watching Peep Show. It's very funny. And in one of the episodes, Jez and Mark's friend, she's going a little bit mad and she's starting to like lose her will, and they have her sectioned and everything, but she hands over her her bar, as in her pub, and all the documents with it. She just hands it over without any thought whatsoever. So that would be, for example, an unconscionable bargain, because they knew she wasn't in now, even though she's not technically incapacitated, like she wasn't drunk, she wasn't a minor, none of those things. Unconscionable bargain is that equitable catch-all where the person isn't yet sectioned, but you know that it's not a fair deal. Equity comes to the rescue wherever the parties to a contract have not met on equal terms. So there you have it. That is the difference between rectification and rescission. I have to say I learned a lot because I never really thought about it in terms of equity and contract, and now I have. So I hope you learned something from it. Sorry, the puppy is making so much noise, but like literally he cannot be in a room, like he can't be in a room on his own. So he's just, the odd time he's here, but anyway, he stayed on the ground for most of it. Anyway, thanks for tuning in. I'll see you in the next one.